there's a protective order in place because it was drinking. Now, there are a lot of people who drink, sometimes to intoxication at their home, but it doesn't result in a protective order. So, all right. And who's the person who wanted to speak to me? Who wanted to speak with me? Oh, come forward. We have Bashan and prosecutors. They're on high alert. Hi, what's going on?
Okay, I was in court this morning, kind of left a little unsettled. I know you had mentioned if there's anything that we need to be successful to come to the court or come to you and request that. So that's why I'm here. I'm having some issues with my attorney, but not so much.
Oh, no, here's the thing. Let me explain to you about attorneys. When people want to say something, the issues they're having with their attorneys, I require that the attorney be present.
Okay.
And just as if your attorney wanted to say they had issues with you, I would want you to be present.
Absolutely.
So we can see if we can have your attorney come back and then, okay?
Okay.
All right, sure, just have a seat. Court is calling 2024 CR 008361, State of Texas versus John Mark Horton.
Scott Sullivan, Mr. Horton, present, right?
For the state.
And
are you Mr. Horton?
Hello.
Yes, are you Mr. Horton?
Yes, ma'am.
All right. Did you understand you're charged with possession of a controlled substance, penalty group 2, less than 1 gram, as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yeah.
If you have a plea bargain agreement with the state, the
Yeah.
court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he's ready to do the community service. As the court knows, this court committed him to lifetime fitness. I think that the recovery.
Oh, lifetime recovery.
Lifetime recovery.
All right, lifetime fitness, I'm not doing that for anyone, unless they specifically ask for it.
No, you came back in great shape. I don't.
Yeah, I did.
Yes, lifetime. Okay, I'll just get past that part. We're aware there's some conditions there with respect to, he's got a hernia right now, and I guess they can take care of him on the community service side. Now, this case has had so many different cases.
Did you catch that? The defense attorney just revealed a bombshell. The son is in the courtroom and wants his father to come home. This completely reframes the entire narrative. We're no longer just talking about a state jail felony. We're now in the middle of a deeply emotional family reunion story. The attorney is making a passionate plea, stating that Mr. Horton is sober and cleaned up, and he's ready to go home. This is a strategic move to humanize his client in front of the judge. But here's the critical legal catch the attorney mentions. I told him to take the position to stay away from his son, because at one time, there were some protective orders, and they might still be true today. This is a lawyer covering his bases. He's admitting to the court that he has advised his client to comply with a potential court order, even if it seems unjust, because violating it would be catastrophic. This moment is a huge risk. Is the son's presence enough to sway the judge, or will the strict letter of the law prevail? What would you do if you were the judge? Prioritize the apparent reconciliation, or stick to the protocol of the protective order?
Cases, I want to make sure I know where an order is and that I address it. His son is here today. He is, to this point, I told him to take the position to stay away from the son because at one time there were some protective orders, and they might still be true today, and I think they probably are. His son is here, and his son wants him at home. He's available to talk to Corey if he'd like to. And this man is sober and cleaned up, and he's ready to go home and be able to be with his son. If you'd like to talk to him, he's available.
All right. How long have you, well, let me have you, well, you've already been sworn in. How long have you been sober?
Going on 6 months on the 22nd.
All right. And what were your issues with your son that involved a protective order?
I drank a lot of beer.
Okay.
No, it's wonderful.
No, I'm glad you're being honest.
Yeah.
So you've been at lifetime recovery. Are you still at lifetime recovery?
No, I go to Club 12 now.
Okay.
I'm gonna be a member there.
Oh, that is awesome.
He's
So,
got and I think it's 120 days, he has to go every day.
all right, where are you currently living though? No, I mean, is it a
My
sober
house,
at your home?
yes.
And if I could, I'd just put in, while he's been there, his son has been staying with someone else.
Okay.
Because he went into that house when he came out of Lycon about a week ago.
There's a protective order in place because it was drinking. Now, there are a lot of people who drink, sometimes to intoxication at their home, but it doesn't result in a protective order. So.
That's what I was thinking. It may have been a condition of bond, or it may have been something that got linked up from the days of the protective order on the misdemeanor, whatever the misdemeanor was.
All right, family violence or criminal
was-
trial division, does anybody know about a protective order he has where his son is Jacob Horton?
I think it may have been a condition of.
I don't know.
There was a misdemeanor for violating the protective. I think that's what it came from.
Well, what I can tell you, if the misdemeanor court, if there's a protective order there, you probably need to take it up with the misdemeanor court judge.
And I don't think they have.
No,
I'll check into it for him.
I've already cleared up all my cases. This is the only case I have.
And if that is the case, I'll verify this afternoon then.
Well, it's just that sometimes when there's a protective order, it doesn't matter if your criminal case has been cleared up because
Right.
protective orders are civil.
I agree.
Yeah.
And I wasn't sure if there was one.
I don't know if there's one pending or not, but what I can tell you is I'm not going to allow your son to stay with you if there's a protective order out there. That's a hearing for another day.
And I will hustle up and find it.
Okay.
Okay. Please remember, sometimes on that soul stuff, they don't
Well,
invite us.
can I go ahead and just do my 6 months in jail? I'd rather go ahead and just go to jail.
This is the emotional peak of the entire hearing, and it's absolutely heartbreaking. Mr. Horton, faced with the bureaucratic nightmare of an unclear protective order, essentially gives up. He'd rather just serve 6 months in jail than continue living in this limbo where he can't be with his son. This is a man who feels trapped and defeated by the system. He pleads, "Ma'am, my son and me, we." He doesn't have any place to go. But the judge, to her credit, doesn't get swayed by the emotion alone. She lays down the law with brutal, necessary clarity. She explains that even if he serves his time, the civil protective order would still be waiting for him when he got out. This is a vital legal insight that many people don't understand. Criminal cases and civil orders are separate tracks. One deals with punishment for breaking state law, the other with protection between individuals. The judge is preventing a future disaster here, because if he moved in with his son and an order was active, he'd immediately be hit with a motion to revoke and face even more jail time. It's a tough love moment that highlights the frustrating but necessary boundaries of the law.
I'll get it over with.
Mhm.
I'd rather do that, ma'am.
Well, let me
Because
just
my
ex-
son and me,
Let me explain something to you.
he doesn't have
even-
any place to go.
Here's the thing.
He's got his brother, but his brother doesn't like him.
Don't interrupt the judge.
All right, so this is what you need to listen. And I want you to internalize what I'm saying. It doesn't matter if you were to get 6 months in this case and go and do your 6 months time, you know what would still happen? If there is a civil protective order out there, when you got out of jail, that protective order would still be there and you all still would not be able to live together. That protective order doesn't have anything to do with the 187th District Court. It's a civil matter. A civil court probably enacted that. This case is a possession less than a gram case.
Okay.
I didn't put a protective order on, for you against your son or whatever, because this is a drug case. And there's nothing that would have come to me through a police report that suggests that you even have children. This police report doesn't mention anything about you having children. All it mentions is that you were day drinking. So,
And by the way, Your Honor, you've said this several times, with so many other cases running around, I've never been able to determine that myself. But I can go to the civil side of the court once, and I think I should, and find out how I can advise my client on that. But with respect to this court, as I understand it, there will be no order of
well, what I can tell you is
if it happens.
if there is a civil protective order, and if he violates that, guess what? I'm going to get a motion to revoke. and it's going to say that he broke the law.
No, I got time served on that charge, so that protective order went away as soon as I got time served.
Okay, here's the thing. Those are two separate matters.
I know it was a misdemeanor court 11, and the judge, he gave me credit for time served.
All right.
Let's just pause and appreciate this judge, because she is doing an incredible job acting as a public educator right now. She's breaking down a complex legal concept in real time for a confused and frustrated defendant. The distinction between civil and criminal law, one of the most confusing things for people outside the system. She explains, protective orders are civil. They're not necessarily criminal. They only become criminal when people are violating them. This is the absolute core of the entire conflict in this case. Mr. Harton is conflating his closed criminal case, the family violence assault, where he got time served, with the standing civil protective order. He thinks because one is done, the other should be too. But the judge is patiently explaining that they are two different beasts. This is where the system can feel incredibly Kafkaesque. You can serve your time, fulfill your criminal obligations, and still be bound by a civil order that restricts your freedom. It's a harsh reality, and you can see the weight of it dawning on him. Do you think this system is fair, or does it set people up for failure?
So, but let me just tell you, protective orders are civil. They're not necessarily criminal. They only become criminal when people are violating them. Then you can get a criminal case for violation of a bond or protective order, but they are civil in nature.
But whenever I got the assault family bond with my son, they put a protective order.
Yeah. So that has absolutely nothing to do with
And they
this.
signed an affidavit of non-prosecution. I never actually assaulted him, but I was drunk and I was a fool.
Your Honor, if I could, I think what I need to do is, I think you can go through with this. And we've requested not to have that condition here, but we have to honor the conditions of a family court. I will do that for him and advise him specifically if there is or is not one.
Okay.
Daniel, like you said, honestly, I've not seen anything on protective order. I've seen the violation of bond. I feel protective order case that's currently open. Not seen protective order. I'm kind of asking some protective orders can verify that.
Yes. And so, and that violation bond protective order, that's a misdemeanor court.
Yes, sir.
So that needs to be handled with the misdemeanor court.
So I just don't know if there's an actual protective order that's not verified.
And I think that, if they did, I think they closed.
All right. So are you employed, sir? Are you employed?
No, I'm retired.
All right. Retired from what?
63 years old. I'm retired. I worked.
No, I mean, what did you do in your past
I worked at
life?
a restaurant for 14 years, but I can't work with a hernia right now.
Okay.
I got it in the county jail.
All right. The court.
And there we have it, the moment of sentencing. After that emotional roller coaster, the judge delivers her ruling. She sentences him to 2 years in a state jail facility. But here's the key: it's suspended, and he's placed on probation for 3 years. This is a massive win for Mr. Harton. He's not going to prison today. The judge clearly listened to his progress, his 6 months of sobriety, and his commitment to recovery at Club 12. She includes standard conditions like a $2,000 probated fine, 150 hours of community service, and crucially, daily sober support meetings. But notice her compassion even here. She makes a note that if he brings proof of his hernia, she figure out something else for the community service. This shows a judge who is trying to balance punishment with practical support for rehabilitation. The central conflict, the protective order, is left unresolved, but she's giving him a pathway to succeed on this charge. The ball is now in his court to sort out the family court matter, but he's avoided the worst-case scenario. It's a second chance, but the clock is ticking.
Then will find you guilty. Court will sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's a $2,000 fine. That will be probated. Restitution to SAPD for drug testing. $150 of community service restitution. And if he brings me proof of the herniated disc that he can't do community service hours, I'll figure out something else.
Okay. Oh,
There's going to be daily sober support meetings. Everything else you need from the court to be successful?
do you need anything else from her to be successful?
No, I really appreciate you having the opportunity to send me over there because the program is an excellent place to get recovery.
Oh, I'm so glad. I think it's a
It
great,
changed my life and my outlook on everything. So I've internally accepted that I can't drink. So that's a big plus for me.
all right, awesome. And if you ever feel like drinking, that's why you pick up the phone and you call somebody, okay? Even if it's to call probation and let them know. All right, good luck to you. Probation is going to go over conditions with you. And once she's gone over conditions with you, you're free to leave.
Okay,
Thank you.
Really?
My name is Happy. I upload courtroom video for education purpose. This video may contain copyrighted works not specifically authorized for use, but believed in good faith to be protected by the fair use doctrine under Section 107 of U.S. copyright law.
So, what are the final takeaways from this legal and emotional saga? John Mark Harton was charged with possession of a controlled substance, a state jail felony. Despite the initial charge, the hearing became dominated by the unresolved issue of a civil protective order barring him from living with his son, a remnant of a prior family violence case. The judge, demonstrating a masterful understanding of the separation between civil and criminal law, refused to override that order in her courtroom, correctly identifying it as a matter for a different court. However, acknowledging his 6 months of sobriety and commitment to recovery, she sentenced him to 3 years of probation, suspending a 2-year jail sentence. The ruling was a balanced one. It held him accountable for the drug charge while providing a structured path for his rehabilitation, but it also underscored a harsh truth that the justice system is a complex machine with many moving parts, and solving one problem doesn't always solve them all. His fight to reunite with his son is a battle that has simply moved to a different courtroom. If you found this case as shocking and insightful as we did, make sure to hit that like button. Share your thoughts in the comments. What would you have done differently if you were the judge? And don't forget to subscribe for more jaw-dropping courtroom breakdowns.